Hello and welcome to the LLG Grapevine podcast. You're listening to Helen Bennett, LLG's Executive Director of Policy and Governance, and Dennis Hall, LLG Bulletin Editor.
Hello, everyone.
Hello, Dennis. Now, last week saw the announcement that there are 6 areas in England which have been selected for the government's devolution priority programme, with mayors to be elected by May 2026. I'm sure you know which areas they are, but in case not, let's run through them. Cumbria, Cheshire and Warrington, Norfolk and Suffolk, Greater Essex, Sussex and Brighton, Hampshire and Solent. The Ministry of Housing, Communities and Local Government will launch a consultation shortly. Devolution will continue to dominate the agenda, so let's move on to other matters. Now, Dennis, a little bit of Latin to start with, perhaps.
Well, Helen, we speak of nothing else here in County Durham, and on this occasion it's habeas corpus and care orders, a matter which will be of some interest to childcare lawyers. The Supreme Court has dismissed a father's challenge to a local authority care order which he based on the remedy of habeas corpus. This is the important case of the father and Worcestershire County Council. Family law specialists said today's judgment in the Worcestershire County Council clarifies the scope of the historic doctrine in family proceedings. In 2022, the Family Court made an interim care order that placed the father's children in foster care. The father did not appeal the order because he thought it would mean he accepted that the order was valid. He also thought, because he did not think the order was lawful, that he could not apply to have the order discharged. The interim care order remained in force. Now, in a significant judgment handed down by the Supreme Court, the court explained that under the care order, parental responsibility was shared between the council and the children's parents, so that the father could have applied to discharge the order itself. 5 justices agreed that the lawfulness of a care order is relevant in an application for habeas corpus only if the order is for the detention of a child. Habeas corpus may be an appropriate remedy where, for instance, foster parents locked a child in their bedroom for a month. However, the Supreme Court said the child would be released from the foster parents, not from the local authority's care. The availability of habeas corpus would be extraordinarily limited, as there must be an allegation of extreme or unusual circumstances amounting to the unauthorized detention of a child, the Supreme Court said. For the claim to have a real prospect of success, there would have to be failures within the regime for looked after children, the court added. The father, incidentally, represented himself in the Supreme Court proceedings.
Well, I know that commenting on the significance of the judgment, Tony Rowe, who's a partner at Dexter Montague, said that the Supreme Court's ruling left the door in relation to habeas corpus slightly ajar. Nevertheless, he added that bearing in mind the elaborate and carefully balanced procedures contained within the Children Act 1989, the scope for habeas corpus claims in relation to children is limited, save perhaps in wholly exceptional cases. Now, in other news and taken from an LGA report and reported in the Local Government Lawyer, councils have issued warnings over the removal of fire and rehire without replacement mechanisms for making contractual changes. This is in a briefing on the Employment Rights Bill. The LGA insisted, however, that the use of fire and rehire is rare in councils and is very much treated as a last resort. The LGA stated it's keen to work with Parliament and Government to ensure the Employment Rights Bill is workable for local authorities and that resulting costs, which are a concern, do not exacerbate the stretched budgets of the sector. As an organisation, it says, with a history of sectoral and national collective bargaining, we have, the LGA said, significant experience in many areas covered by the bill.
Well, Helen, the LGA has said that the removal of the possibility of fire and rehire without a replacement mechanism for making contractual changes will impact on councils' ability to implement equality-proofed pay structures, or indeed to deliver local government reorganisation. And the LGA also expressed concern that the limits which would be placed on the use of fire and rehire through new clause 22 in the bill would in effect make the use of it by councils almost impossible. The LGA further explained the rationale behind this as being because the circumstances in which the exception to the right to claim automatic unfair dismissal applies in cases of fire and rehire are very limited. It appears to apply only where businesses are dealing with severe financial difficulties and where they need to make changes to employment contracts to allow them to cut costs to keep the business afloat.
Well, yes, such circumstances are very unlikely to apply in the case of councils, the LGA argued, as I understand it, because it would be rare for local authorities to be able to demonstrate that the financial pressures were such to fall into the category covered by the exemption. For a council to do so, it's likely that it would need to have issued a Section 114 notice. And the LGA said the issue of such a notice obviously carries serious consequences, and therefore they would only be issued where absolutely necessary. So for those keeping an eye on the Employment Rights Bill, here's a little roundup. It was introduced to Parliament on the 10th of October last year. The House of Commons committee stage ended on January the 16th of this year. Parliament has published an updated version of the bill, and that incorporates the amendments accepted during the committee stage. And the bill, of course, will undergo further scrutiny in Parliament, where proposed amendments will be considered. Now, let's turn our attention to the qualification of solicitors. And we've known for some time that something has not been quite right with the SQE due to the low numbers of those passing it. And now the SQE seems to agree. The SRA, I should say, about the SQE. Dennis.
Yes, indeed. You've got to get your SRA and SQEs right in all of this. It's quite a tongue twister. Back to the SRA. Indeed, Helen, rarely are the SRA so candid as to be self-critical, but there are issues, they say, with the new SQE. Regulatory chiefs have admitted that universal approval for the solicitor's qualifying examination is lacking, as it emerged that a key target for helping candidates is being missed. In statements this week, the SRA sought to reiterate its commitment to the SQE, but admitted that the exam had had problems in its first 3 years. Concerns have been raised about the cost of taking the exam, the lack of a breakdown of marks, the absence of past papers, and the nature of the multiple choice questions in SQE 1. There have been further criticisms about reasonable adjustments not being made for neurodivergent candidates and the lack of available test centres. And in a break from the usually trenchant backing for the SQE, the SRA this week accepted that there were issues with the exam itself after receiving feedback from stakeholder groups.
Well, yes, and I know that Chair Anna Bradley said that the board had looked at potential changes when it met the other week, and there's a 5-year plan which will be worked on later this year. And she said, and I'm going to quote, "There have inevitably been some teething problems along the way, and so we have tried to adapt and adjust as we've moved the work forward. One key area," she went on, "has been the changes made in response to feedback about the candidate experience, and it's important," she acknowledged, "that they continue to build on this." Now, in her address to the board, Bradley told members the SQE had been a real success, achieving the primary aim of ensuring that every solicitor was being assessed to the same high standard. But she did add, there continue to be some hearts and minds to win. And of course, there are further improvements to be worked on.
And back to that feedback. Feedback has reported to the board, and this shows that 1 in 5 SQE2 candidates did not think written tasks were at all clear. In the last quarter, the average time to deliver a reasonable adjustment plan for candidates with special needs crept over the SRA's own target of 6 days. Now, the SRA has no concerns about the pass rate, apparently, for SQE1, which hovers at around 50%. And again, it's felt by management that this is a signal that the test is robust and ensuring a high quality of new solicitors.
Well, I think there are people that would dispute that, Dennis. But I know many have recently taken the SQE, including one of our recent interns, and I do wish everyone the best of luck with their results and the fortitude to continue on their path. Now, in other news, the LGA has sought to improve effective working and support between employees and employers in a new councillor guide. The LGA states that the guide has been developed for people in employment who wish to stand for election or are already councillors and their employers. It's easy to forget that councillors often have a full-time job, but not always. The guide sets out practical considerations for both employees and employers to ensure staff can be supported in this community role whilst ensuring business needs are met, and at the same time reaping the mutual benefits of contributing to civic life. The aim, no doubt, is to encourage more widespread representation from a range of individuals serving the community as councillors. I looked at the statistics here, and in the last 2022 census, male councillors outnumbered female councillors by a third, and 50% of councillors were over the age of 70, with the bulk in total aged 50 or over. Now, employers are required under the Employment Rights Act to provide reasonable time off for various public duties, which includes local councillors. Those of you who are school governors, incidentally, will also fall under this category. So what's reasonable time off? Well, it's going to depend on how much time is usually required to perform a particular task, the amount of time off already permitted, and of course, the impact on the business. Now, this is separate from any flexible or part-time working arrangements, but the employer can refuse a request for time off if they think it's unreasonable. Of course, local authority employees in England cannot hold the position of councillor for the authority in which they work under the 72 Act. However, they can stand in another authority. Lawyers, however, need to be more careful because under the Local Government and Housing Act 89, most will be caught by politically restricted posts and cannot stand in any authority elections, with the interesting exception, however, of parish councils, provided, of course, they're not employed by one. Dennis.
Interesting. Now, our next item demonstrates how local authorities, acting with initiative, can take forward one of the key policy goals of the government, the need to increase the amount of affordable housing. Some 140 registered providers and more than 70 local authorities have registered as potential buyers through Homes England's new Section 106 Affordable Housing Clearance Service in its first 50 days. More than 70 householders have registered to provide details of affordable homes that they have planning permission to build alongside private homes, but have been unable to find a buyer for. Homes England said it is hoped the service will play its part in facilitating and accelerating the sale of uncontracted and unsold affordable homes across England, excluding London. Chief Customer Officer Ian Workman said, "This is a relatively simple but potentially impactful service that means greater visibility of opportunities to get affordable homes sold and occupied. I would urge house builders," he said, "in particular, to register and add as much detail as they can." Over 200 registered providers and local authorities have already signed up and are regularly checking for potential opportunities to acquire homes for the communities that they serve. Housing Minister Matthew Pennycook said, "We recognise the challenge posed by the reduced appetite of registered providers of social housing to buy affordable homes delivered under Section 106 agreements." He went on, "The new clearing service that we have worked in partnership with Homes England to establish will help improve the functioning of the market and unlock the delivery of Section 106 affordable housing." Councillor Adam Hugg of the LGA, and he's the housing spokesperson, said, "This service is a positive step to promoting stalled sites to registered providers of affordable housing, and the LGA encourages all local authorities to engage with it. But it is just one tool which will help provide and bring forward more affordable housing. Much more needs to be done," he said. Kate Henderson, Chief Executive of the National Housing Federation, also said, "Building new relationships between developers and social housing providers is important in overcoming the immediate challenges, as well as helping developers to understand the requirements of housing associations in the future." Helen, this is a simple, practical, but effective step. Let's hope more authorities join this new initiative.
Well, let's see, Dennis. And finally, turning to our lovely colleagues in Wales and this week's Welsh Bulletin. So the Senate's Legislation, Justice and Constitution Committee remains concerned that it's becoming more difficult for the Senate to perform its function of scrutinising legislation affecting Wales. Now, these concerns were first raised in the committee's annual report 23-24, published at the end of last year, which argues that the Welsh Government's use of framework bills and the volume of UK bills being used to legislate in devolved areas are contributing to these difficulties.
And the committee commissioned Professor Richard Whitaker of the University of Leicester to undertake research into the use of framework bills, not only in Wales, but also in the rest of the UK. And the research found that a substantially higher proportion of framework bills have been passed in the first 3 years of the 6th Senate compared to the Scottish and UK Parliaments over the same period. In the Senate, 43% of all bills passed in this period were considered as framework bills, compared to 10% in the Scottish Parliament and 9% in the UK Parliament. The annual report cites the Local Government Finance Wales Act 2024 as an example of legislation which provides an inappropriate delegation of power to the Welsh Government. In its report on that bill, the committee stated that through the bill, the Minister is asking this Senate to grant broad delegated powers to an unelected future government for unknown reasons, and to do a wide range of things that are not necessarily understood today. The excessive granting of secondary legislative powers denies the Senate its proper constitutional role.
Well, one of the Welsh Government's points in response to the committee's conclusions was that the proposed approach set out in the bill is a significant improvement in comparison to the system we have relied on to date of seeking consents for Wales through UK Parliament bills. The committee, it seems, is also concerned about the increasing volume of bills passed in the UK Parliament in areas devolved to the Senate, following increased instances of the UK Parliament legislating in devolved areas without the consent of the Senate. The committee's report notes that the former Counsel General, Mick Antony, described the Sewell Convention as, quote, wounded. The report sets out details of the discussions the committee held with the then Counsel General and the former First Minister Mark Drayford on reform of the convention, including whether it should be codified. And on that note, that's it for another edition of the podcast. You can read more on the items discussed today and many more besides by going to bulletin number 5, available on the LLG website now. So it's goodbye from me.
And from me too. Bye now.
Bye, Dennis.